Welcome to RJA Impact. Today we're going to be talking about the Duke of York's answer paper filed in court on Wednesday the 26th of January 2022. This is a response to Giuffre's complaint filed in August 2021, which I'll call the complaint from now on. Well, here it is. Having tracked it down, you can see that it was filed in the US District Court, Southern District of New York, and is entitled Answer and Affirmative Defences and Demand for Jury Trial. The document is 11 pages long, and you can see from just this first page there are a lot of statements saying that Andrew either denies an element of the complaint or lacks sufficient information to admit or deny the complaint. It is quite thorough, however, and appears to address each paragraph of the complaint in order. Clearly, to explain what points are being addressed as we look through the document, we're going to have to look through the original complaint filed by Giuffre side by side. Here is that original document, which I'll put side by side with Andrew's answer, and pull out some of the detail so we can understand what's going on with the Duke's responses. To get started, let's look at the first two paragraphs. Here Giuffre says this suit arises out of the defendant's sexual abuse of the plaintiff when she was under the age of 18 years old. And here the Duke's response is, Prince Andrew denies the allegations contained in paragraph 1 of the complaint. The second paragraph in the complaint says, during 2000 to 2002, beginning when the plaintiff was 16, the plaintiff was the victim of sex trafficking and abuse by the convicted sex offender Jeffrey Epstein. And here's the Duke's response. Prince Andrew lacks sufficient evidence to admit or deny the allegations contained in paragraph 2 of the complaint. This answer of not being able to admit or deny the allegations is a common theme in the Duke's filing and tends to refer to the items in Giuffre's complaint where Andrew wasn't present. For example, where Giuffre talks about the actual process of being trafficked by Epstein and or Maxwell. Whenever there's a direct allegation, however, against Andrew, for example here in paragraph 6, Andrew makes a direct denial. Number 6 reads, one such powerful man to whom the plaintiff was lent out for sexual purposes was the defendant, Prince Andrew, the Duke of York. And Andrew's response is, Prince Andrew denies the allegations contained in paragraph 6 of the complaint. Let's go through this and pick out what's relevant, pertinent and of interest as we go through the answer line by line. It's interesting here that Andrew denies being a close friend of Ghislaine Maxwell, who was recently found guilty of sex trafficking for Epstein. Well, I guess any close relationship with her would be toxic if put in front of a jury, so he must deny it. The term close friend is so subjective anyway that it is probably a pretty meaningless allegation. Paragraph 10. Prince Andrew committed sexual assault, battery and emotional distress on Giuffre, which was denied by Andrew. In the next section, parties, Andrew is disputing that Giuffre is domiciled in Colorado, US, and this is part of Andrew's claim that Giuffre, who's lived in Australia for over a decade or so, cannot bring a claim in the US as she does not live there. Judge Kaplan has already ruled that she is domiciled in Colorado, but the Duke is evidently still progressing with this specific claim. Jurisdiction and venue. In this section, primarily Giuffre makes the claim that the New York City Court has valid jurisdiction to host the case, and Andrew's answer is that these are legal opinions and don't require a response. Factual allegations. In this section, Giuffre tells the story of how Epstein and Maxwell ran their sex trafficking enterprise and how they used his wealth to intimidate them and create an environment where the abuse was normalised. And Giuffre herself was abused by Epstein in places such as Palm Beach, New York and the US Virgin Islands, where Epstein owned a private island called Little St. James. In paragraph 27, she makes the direct allegation that she was forced to have sex with the defendant, in other words Prince Andrew, and he denies this allegation. Defendants allege sexual abuse of the plaintiff. In this section there are more direct claims of abuse by Andrew on Giuffre, and specifically this mentions when she was under 18 years of age. In this section we also see the infamous picture of Andrew with Giuffre and Maxwell in the background. It is alleged by Giuffre that he sexually abused her after this picture was taken. It's interesting on this point that Andrew says he lacks sufficient information to admit or deny the allegations. Well, this is baffling to me. Why does he deny all the other allegations, and yet in respect to this picture, he says he lacks sufficient information? We know that he and his aides have claimed that the picture was doctored, and also he has said that he doesn't remember meeting Giuffre. Why didn't he directly deny this allegation too? Well, your guess is as good as mine. In paragraph 44, Andrew denies ever engaging in any sexual acts with Giuffre. It also says in this section that Giuffre feared physical injury to herself and other repercussions for disobeying Epstein, Maxwell and the Prince, which is one reason why she was compelled to participate. The arrest, prosecution and death of Epstein and Prince Andrew's refusal to cooperate with the authorities. This section in Giuffre's complaint talks about Epstein and his prior conviction for having sex with an underage girl. One tangible link to the Duke is reference to an email from Prince Andrew to Maxwell saying, "Let me know when we can talk. Got some specific questions to ask you about Virginia Roberts." And Roberts was Giuffre's maiden name. Well, if that's true, then the Duke's denial of ever knowing her loses all credibility in my eyes. His response was that he lacks sufficient evidence to admit or deny the allegations. Giuffre also alleges that Andrew was a co-conspirator with Epstein and Maxwell in the sex trafficking, to which Andrew denies. Also, Giuffre quotes from the Royal website and the Newsnight interview where Andrew says, "Of course I am willing to help any appropriate law enforcement agency with their investigation, if required." Her complaint then goes on to state that Andrew has refused to cooperate with the US authorities, despite the FBI and prosecutors reaching out to him, and he denies this. First cause of action, battery. This is where things get very heavy for the Duke, and I'm going to read out paragraph 67 first. Prince Andrew's actions constitute sexual offences as defined in the New York Penal Law Article 130, including but not limited to sexual misconduct as defined in Article 130.20, rape in the third degree, as defined in Article 130.25, rape in the first degree as defined in the Article 130.35, forcible touching as defined in Article 130.52, sexual abuse in the third degree as defined in Article 130.55, and sexual abuse in the first degree as defined in Article 130.65. Well, essentially, if this case is found against the Duke, then what will be found is that it was more likely than not, on a balance of probabilities, that the Duke is a rapist and sexual abuser as defined in penal law. I should note that this is not a criminal trial where the threshold is beyond all reasonable doubt, but this paragraph should scare the hell out of him. He of course denies the allegations. Second cause of action, intentional infliction of emotional distress. As the title of this section states here, Giuffre makes the case that as a result of the prior allegations, the Duke committed intentional infliction of emotional distress against the plaintiff. It is quite harsh in its language, for example using terms like extreme and dangerous conduct and goes beyond all possible bounds of decency when applied to Andrew. Okay, so that's the line-by-line refutation made by Andrew. We then have several sections dealing with defences. First, affirmation defence, lack of subject matter jurisdiction. We've already covered this to some extent, and Andrew's lawyers are maintaining that Giuffre is not a domiciliary of Colorado and therefore the jurisdiction of the court is lacking. Second affirmative defence, waiver and release. Here the lawyers maintain that due to the settlement with Epstein, which covered a broad third-party release, that Giuffre has already waived the right to make the claims in the complaint. Third affirmative defence, lashes. Giuffre is barred in whole or in part from obtaining the requested relief based on the doctrine of lashes. I read that out verbatim and had to look it up. Essentially it refers to a lack of diligence and activity in making a legal claim, often quoted as an unreasonable delay in pursuing a right or claim, or that Giuffre has essentially slept on her rights, so for example witnesses or evidence might be lost or not available. There you go, I learned something new today. Fourth affirmative defence, damages contributed to by others. Here the Duke's lawyers make the argument that if Giuffre did suffer injury or damage, then it was others and not the Duke who were responsible. Fifth affirmative defence, consent. The point being made here is that Giuffre consented and therefore her claims are barred. This is odd because Andrew has denied all the allegations, so how could there be a consent element claim in his defence? Now I think the lawyers are throwing all possible defences against the complaint, which would be typical, hoping that at least one will stick. Sixth affirmative defence, unclean hands. Giuffre's alleged causes of action are barred in whole or in part by her own wrongful conduct and the doctrine of unclean hands. I think this is in part reference to the fact that during Maxwell's case, one victim claimed that Giuffre herself recruited her to become a victim. The answer doesn't mention this explicitly, however, is my thought. He who comes into equity must come with clean hands is a maxim in English law. Seventh affirmative defence, estoppel. A person cannot assert a right if it contradicts what they previously said or agreed to by law. Again, the answer doesn't specifically mention what contradictions there are. Now, I'm aware that Giuffre has made some contradictory statements about her age when the alleged abuse took place, but I'm not sure if this is what's being referred to here. Now, I'll just read out the next few affirmative defences verbatim, as they're all quite short and self-evident. Eighth affirmative defence, statute of limitations. Giuffre's claims are barred in whole or in part by the applicable statutes of limitations. Ninth affirmative defence, speculative damages. Giuffre cannot recover the damages alleged in the complaint because such damages, if any, are too speculative to be recoverable at law. Tenth affirmative defence, no right to exemplary or punitive damages. Giuffre's prayer for exemplary or punitive damages is barred because the complaint fails to allege facts sufficient to entitle Giuffre to recover exemplary or punitive damages from Prince Andrew. Moreover, any award of punitive damages is unconstitutional if it is excessive under the Due Process Clause of the 14th Amendment. I'd just comment here that we don't know at this stage what damages are being sought by Giuffre. 11th affirmative defence, failure to state a claim. Giuffre's causes of action fail to state facts sufficient to constitute viable causes of action against Prince Andrew. Additional affirmative defences. Here Andrew is saying that there may be more defences that he calls upon, as there is insufficient information to allow him to know whether there may be other defences available. Prayer for relief. Essentially, this is just saying that Andrew requests all the allegations be dismissed with prejudice and the court find in favour of Andrew. Jury demand. Prince Andrew hereby demands a trial by jury on all causes of action asserted in the complaint. There's been a lot of comment on this point. It has been mentioned that the case would go to jury anyway, and this is what Giuffre has requested, so it's a bit of a moot point. I think what Andrew's lawyers are trying to do is to control the narrative. In other words, make it appear that Andrew is confident of his defence, and so going in front of a jury is not something that scares him. Well, that's the run through. It didn't take as long as I thought, so I kept it down to one video. Takeaways? Only a couple of comments. Given that a lot of the answers state that there's not enough evidence in Giuffre's claim, it means that there's likely to be a lot more exchange of information as we move towards the trial. Also, we've not heard the depositions yet of Andrew and Giuffre, so a significant part of the evidence, i.e. their testimony, is yet to come. Thanks for watching. Please don't forget to like and subscribe, and if you hit the notification button, you won't miss out on any further videos as they're published. Bye for now.